And thanks, Emily. Thanks to Applied AI for having me. Thanks for all the sponsors. Yeah, let's do it for that. Right. And thanks to all of you for coming out. Thanks for being part of the AI community here in the Twin Cities. The work you're doing is very important in building up what we're doing here and trying to build industries and build companies up here that are getting in and being a part of this revolution, I think it's fair to say. So my name is Tom Corbett. I'm an attorney. I've been an attorney for about 19 years. Just as a quick background, I went to law school at the U of M, finished in 2005, worked at a law firm for about 5 years in commercial and corporate work, technology work. I was at Target for about 5 years. Anyone else a Target alumni here? Anyone used to have the discount? Okay. Great company, did a lot of the technology work there, buying things that that Target uses from the point of sale systems you see on the aisles, all the way up to the robotic systems in the distribution centers, which you don't see. Then started working remote in 2015 for a company called SAP Concur, travel and expense management solution. Then to GitHub, I'll talk a little bit more about that in a minute. And currently my day job is head of product and privacy counsel at Eightfold AI, which is using AI in the HR space for talent acquisition. So that's a little bit about me. So what are we going to do here? First of all, we're going to get the slide to advance. So just a few preliminaries, kind of a quick tour of the AI landscape, at least as I see it. The emerging law of AI is kind of the main course, and then plenty of time for Q&A. So I'll try to wrap up by the top of the hour and take questions then. If you have any questions during the middle of the presentation, just feel free to raise your hand or shout them out. I'm happy to stop along the way and discuss anything that might be on your mind. So lawyers love disclaimers, right? So all opinions here are my own. This is not legal advice by any means. I've worked a lot of different places. I'm not representing any of them in that capacity tonight. I'm speaking for myself. I also have a law firm on the side where I do a bit of consulting as well. So it's probably more in that capacity. So who I am, I kind of told you what I did, right? But like, what does that mean? There's a lot of people talking about AI these days. There's a lot of people marketing themselves as having worked in AI. So why am I worth listening to than the next lawyer or the next person? So, credentials, right? I worked on GitHub Copilot. How can I prove that I actually worked on it, that I didn't just say that I worked on it? Well, you might get a shout out from the real rock star of GitHub Copilot, who's a gentleman named Erga Demore, very brilliant fellow, the leading man of the rock band in a sense, and, Oxford educated, smart as the day is long. And he was really the driving force behind it at GitHub. He was the first person who just sort of by serendipity, I had the pleasure of getting to work with at the ideation stage of, hey, let's work with this company, OpenAI. Maybe we can have them train on our public code on GitHub. What do you think about that? So that was sort of the origin of it. It was a lot of serendipity. I didn't seek out to work in AI. It just happened to fall into my lap. And it was a great ride. So other than that, developers have a great way of kind of showing the coin of the realm, like where you were in the crew that worked on something. And it was swag at GitHub. GitHub had great swag. So I got the official Copilot thermos or whatever, and then the official GitHub Copilot beach towel, which still gets a lot of use around my hot tub. So the swag was really for people who worked on the project day to day. So anyway, so those are my bona fides. What about Copilot? Many of you are probably familiar with it. Right now, it's the world's most widely adopted AI tool. Businesses have gravitated to it. Individual developers have gravitated to it. And I'm very gratified to know that it's a generative AI product that's actually making people's lives better and is also being able to be commercialized. So as an attorney, that's kind of nice, where you're improving people's lives. You help create a product that people are also willing to pay for. When was I working on this? Right here, June of 2021 is when we released it in beta. We were working on it up until that point. When they mentioned we'd be working with OpenAI, I didn't know who that was. I'd never heard of them before. Most people hadn't when I was talking about it around the dining room table. And then, of course, by the end of 2022, everyone knows about ChatGPT and OpenAI. So I feel very fortunate that I was a part of something, working on something, and getting a little bit ahead of the curve. So what's the AI landscape, at least as I see it, or how I think about it? This is sort of we can get into some nuts and bolts, like what do exact laws say, or what are the specifics of this particular thing. But for the most part, the next 20 minutes or so, I'm going to talk about kind of how to think about the emerging law of AI, because I think that's probably a lot better use of our time than trying to go too far into the woods. So this is a quote you hear in law school. Like if you go to law school, you're probably going to hear this in your first year, maybe in your first month. So if you ever have cocktail conversation with a law student or a lawyer, you can say, who's a really important Supreme Court justice, and they might just say Oliver Wendell Holmes, right? He's kind of like on the Mount Rushmore of Supreme Court justices. Well, what's something he said? This is probably his most famous quote, right? So the point is that lawyers and societies, they don't sit in a room and think, what's the best way to organize ourselves and what's the most logical way to do it? It's all grows out of experience, right? So how do we think about the experience that we're all living through and how it's informing AI? So where have we been? Internet age, 1990s to present. Social media age, early part of the century to present. Mobile age, early part of the century to present, so with the iPhone. How have we had law keep up with that? Well, the answer is not terribly well, right? Has anyone been to Disney World? Anyone? Has anyone ridden on the Carousel of Progress at Disney World? Anyone? It's over by like Space Mountain, right? It's a rickety old ride. It's kind of creepy in a way. It's got like animatronics. I think it's the only ride there that Walt Disney played a role in designing. And it was, I think, at the World Fair at some point, and then it was moved to Disney World. You're nodding, right? And you ride on this carousel, and you kind of, or I guess the scenes, this panoramas kind of go in front of you, and they play this song, "There's a Great Big Beautiful Tomorrow," right? And I think that was the theme song of about the last 30 years in big tech, right? It's like, don't worry about it. There's a big, bright, beautiful tomorrow. Don't regulate us. Don't crush our innovation. Hands off. And for the most part, that's what we did, right? I don't think we're going to do that again. There's a few reasons. One is, this is like the first time the word robot, I think, was ever used. It showed up in this old Czech play from like 100 years ago. And guess what the robots do at the end of the play? Revolt against humankind, right? It's like the first time we come up with a story about robots. What's the conflict? Well, they revolt against their makers, right? And of course, we got HAL from 2001 and Terminator and Ex Machina, right? We've also just got, bipartisan alignment of like pretty significant problems with big tech, right? Like that's what Washington is starting to come together on. What's different this time too is we have, the risk of white collar job displacement. This isn't John Henry against the steam shovel, right? This might look more like the printing press, where a highly educated scribe who spent their life learning how to read and write and, have excellent calligraphy and illumination of manuscripts might find that their services are a lot less needed when you can pound out a book on a printing press. So you combine these things, kind of our inherent distrust of AI as humans, these other risks, and you're going to get probably more active legislation. This is just a quote I put up there because I think it encapsulates where a lot of people were about a year ago, and maybe I was as well. This is just a shot from The Simpsons. Within 100 years, computers will be twice as powerful, 10,000 times larger, and so expensive that the only 5 richest kings of Europe will own one, right? So I think about a year ago, we're thinking, oh goodness, it's going to be Microsoft, Amazon, Google. It's going to be these huge big tech companies that are consolidating power. So the jury's still out on that, but I'm probably on the other side of this view, because there are things going on in the open source space. There's just things afoot where I think the biggest companies are probably going to be needed for the most powerful computing required for generative AI. Like if you want to sequence genomes or create pharmaceuticals or something highly complicated, you're probably going to need to pay top dollar for the AI that's going to do that. If you're just looking to leverage some sort of large language model to do a more commonplace, everyday, less intensive task, you might be looking more at open source models. You might be looking at other solutions that you don't need a battleship to fight off a pontoon full of pirates. You can use a less powerful tool. Also, there's just things, in my backyard or my former backyard, GitHub Copilot seems pretty revolutionary, right? But it's already at the risk of being disrupted by other companies that are saying, why have something that prompts you for the next lines of code or helps you code? Why not just tell it what you want and see if there's a way for it to spit out the actual completed project? So keeping a close eye on Cognition and others, you can see they say they raised 21 million in their Series A down here, just less than a month ago or a few weeks ago, looking at a $2 billion valuation. So lots going on, even in DevOps. And then, of course, Mistral AI coming out of France, very small team. Microsoft also trying to get in on that as well. But even OpenAI is at the risk of disruption, right? So it's quite a foot race that we have going on. So with all that said, what are the emerging laws in this area? What are some of the norms around them? How do you make law in this area? I think the first thing to know is that AI is already regulated, right? Every piece of technology is already regulated under existing laws. So just because you're using AI to do something doesn't necessarily exempt it from an existing law. So we have the Fair Trade Commission Act from 1914, from way back when. It prohibits unfair or deceptive acts or practices in commerce. It's so broad, right? It's one of the broadest laws out there. What does it mean? What does unfair and deceptive acts mean? You tell me. There's other consumer protection laws. There's hard-fought civil rights laws from the 1960s about the importance of employment, civil rights, equal opportunity. If you're using AI in ways that are violating these laws, you're gonna run afoul of the existing regulatory framework. Copyright Act, of course, still out there. Privacy laws, many others. So there's already existing laws in AI. The debate is sort of, do we think the existing laws are sufficient to regulate this emerging technology? Do we think we need specific AI laws instead, or do we need some combination of those two things? We'll probably end up with a combination of those two things. So before laws come around, there's usually a bunch of norms that come out of kind of the thought leadership in it. And in the world of AI, there's a certain number of notes, there's kind of variations on themes, but these are the types of things that most companies, most regulators are thinking about, these principles or these norms when they're thinking about regulating AI. So this is just 12 of them. These are maybe 12 of the most common. I've read a lot of responsible AI policies over the years. These are the ones that I've found at least tend to come up. And once you start coming up with norms, well, then you can start to come up with, self-regulatory policies. Microsoft, my former employer, they did a very good job of being a thought leader around responsible AI. They arrived at these principles currently in terms of how they think about their AI development. They're often cited as having strong thought leadership. That gets you a spot at the table, when the regulators start thinking about how they want to do it. OpenAI has its own policy, caused them some trouble, obviously, in the last year or so. They had a little bit of a culture clash between the things that they had written on the page and suddenly being a startup worth billions and billions of dollars. Money has a way of challenging principles. Theirs is pretty creative. It's not just about those notes that I showed you earlier. They have some unique things about they want their AI to, broadly help humanity. They're a nonprofit, have a cooperative orientation. That's their mission, right? So if you're working in a company that's trying to arrive at its own AI policy, you can look at those kind of common notes on that earlier slide as a guidepost, but you might want to think about what's something that you're doing in your company that really deserves its own kind of special principle, right? If you're in healthcare and you're using AI, then you probably want to think about a principle that, maybe you want to take human centricity, but you want to move it to the next level, something that's a bit more meaningful to you. Otherwise, they kind of become words on a page, and you're not really going to live them out in your corporate culture. ChatGPT, you can ask it to write a responsible AI policy. It will come up with a different one every week or so. This is the one that I came up when I did it most recently, just the other day. Human-centered design, that's good. That's not always on there. Sometimes they leave the humans out. but you can kind of mix and match these to come up with the policy that you want. So once you have norms and you kind of have self-regulatory policy and you have thought leadership around things, sooner or later, there's probably going to be a point where you want to come up with some laws. So last fall, President Biden issued Executive Order 14110, and it's about how the federal government will use AI. So it doesn't really regulate the private sector, but it talks about how the federal government and all of its might and power will use AI and how it's going to do it in a responsible way. That'll have a normative effect on large corporations. They'll look at what the government's doing. They'll probably start to adopt similar sorts of approaches. What did the executive order do? Well, Uncle Sam wants AI talent. They realize, I mean, that's good news for everyone in this room, I guess. If you work in AI, congratulations. There's a lot of people that are interested in your talents, including Uncle Sam, including state governments, including regulators. Advancing federal government use of AI, they've called for a federal AI talent hiring surge. They're going to try to do that through their existing HR technology. We'll see how that goes. I work at Eightfold, so no comment. But they set out these 8 principles. They should look somewhat familiar to some of those notes on the earlier screen. It's a very long executive order. It's about 27,000 words. I've read it a few times, but they spend 25% of it on the first principle alone. And this is the stuff that if you're a president or you're a senator or whoever else, or you're in the Department of Defense, these are the types of things that should keep you up at night, because it's about AI-powered threats to America, right? Whether they're cyber, nuclear, biological, you name it. So a lot of this executive order is about Uncle Sam rounding up the talent that he's going to need to make sure that we as Americans are kept safe. But there's a number of other very interesting things in it as well. How about Europe, right? We're going to spend a lot of time talking about Europe. And when I talk about Europe, I really mean the EU. I mean the countries in blue here. I don't mean the Europe that's on a Krasmarsik t-shirt, if you're familiar with that restaurant in Minneapolis. Europe often kind of leads the way on a lot of regulation. They did so on privacy. How they did privacy is how they're going to do AI. It looks a lot like how they did privacy, right? They kind of came up with these norms. They came up with this thinking, and they started creating laws that had an international application. And then lo and behold, a state like California adopts a privacy law in about 2020. And now in 2024, I think it's, 13 US states have privacy laws and many more are working on it. So Europe has sort of leveraged its lawmaking approach and position to influence a lot of global thinking around technology. How do they do it? How is it so different than the United States? Well, the Europeans they kind of take this approach. They're logical, they're less experiential. Top down. Importantly, they live through a large part of large segments of Europe live through a large part of a century where they were under authoritarian governments, right? They have a different approach to thinking about the law and the relationship of the individual to the state and the individual to businesses. Of course, many businesses were sort of co-opted during the authoritarian stages. So there's just, we have mistrust as Americans. It's kind of one of our fundamental organizing principles. The Europeans have mistrust as well. It's just in a different sort of way. So before I jump into this, so for privacy, the Europeans passed a law in the late 90s around that. And then they made it into the General Data Protection Regulation, GDPR, which I'm sure many of you heard about. It's a privacy law. It came out in 2016 and it really became effective in 2018. It got a lot of attention from the US because just like the proposed EU AI Act, it has an international application. So the proposed EU AI Act is going to apply if an output from an AI is used in the EU or an affected individual from an AI resides in the EU. So that's a lot. So there's probably plenty of businesses in Minnesota, there's plenty of people probably working at businesses in this room where you only have a US orientation, right? That's the only place where you're doing business. The outputs from an AI aren't going to be used in the EU, or people affected by it aren't going to be in the EU. But there's going to be probably many companies as well where this law is going to apply. So the Europeans have a way of kind of bootstrapping the US into following the types of laws that they pass. And they do it through this sort of international scope of their laws. The other way they do it is with humongous fines, right? So if you followed any of the news around GDPR, you can see that Google and Meta and others are frequently hailed into court, and they're sued for large, or they're fined large amounts, which they then appeal. And that gets the attention of US companies, right? So when I say humongous fines, like a fine for a pretty egregious violation of this law would be 7% of your annual revenue. So that's a very large number. And it might be just based in the EU, but even if it's only based in the EU, it's a very large number. So these things get people's attention. The drafts of them have been in the works for a while, but it is likely to pass this spring. As a general rule, it won't really come into enforcement for another 2 years after that. And maybe the most important thing that the EU AI Act did is it took a risk-based approach to AI. It took them a while to sort that out. So instead of regulating the technology per se, so saying we're just going to regulate AI, we don't like this technology, what they came around to was, we're going to be agnostic about the technology. What we're really interested in is the use cases of the technology and which ones are risky, impermissibly risky, and we're going to prohibit them. Which ones are high risk and just need closer regulation? And then which ones are we going to be less concerned about? So they took a risk-based approach to AI. That's been pretty much adopted by most other jurisdictions that are looking at regulating AI. A few examples of prohibited AI. These are things that, I had a friend from down south, he would use the phrase bad wrong. You probably know you're doing bad wrong if you're doing some of these things with AI. So some of the examples are biometric categorization for certain inferences. So if you're creating a facial recognition software to determine if someone is Catholic or Republican or what have you, you're probably going to run afoul of things. Social scoring of the type that China is doing in terms of scoring residents or citizens and then tying social benefits or social penalties to how well you score. There's all kinds of other social scoring that happens on social media in the United States, but that's not really what I'm talking about. I'm talking more about the social scoring that's going on in China. Future criminality, if you're familiar with the movie or the book Minority Report, the stuff of kind of dystopian sci-fi, that's out. Creating facial recognition databases, emotion analysis, but only in education and employment. So I guess if you had a dating app or something and you wanted to do emotional analysis, you might still be permitted to do that. And then mass surveillance using biometrics. There's a few exceptions for this. There are some law enforcement exceptions for some of these things if these kind of urgent situations arise where mass surveillance using real-time biometrics is going to help prevent very significant crime from occurring. There are exceptions. And anyone who's been to London, for example, knows that, even though they're not in the EU, or Paris, knows that people on the other side of the Atlantic are a bit more comfortable with CCTV monitoring public spaces. So it's kind of a mixed bag. Like, they're probably more privacy sensitive over there, but they're definitely more comfortable with surveillance of that type. What are some, yeah, go ahead.
I mean, if you go back to the other slide, I mean, that's something that China is pretty much doing probably every day. Did that, do they even care?
They do, but for different reasons, right? So China, like in the privacy area, China has its own privacy law. It's somewhat similar to GDPR, but it's very different in how it's applied and what it's there for. So China's concern over AI is mostly about like what they would consider misinformation, deep fakes, putting words in the mouths of their leaders, anything that's going to, kind of stress the social safety net. So, every country will probably have an AI law. The EU will probably be sort of the gold standard in a sense. But yeah, some of these things there's probably great opportunities for international cooperation where everybody's concerned about the same thing that, could cause significant risks to all of us.
Yeah, I mean, you can sue Google and Facebook and all sorts of stuff for these types of things, but how do you sue another country? you know, you said 7% of revenue, like if a whole entire country is doing this stuff, then it's kind of tough for you to enforce it.
Yeah, how you hail companies into court is a challenge, especially if they're in other jurisdictions that are adverse to that. But in the EU, I mean, a large US company like Meta or Google or Microsoft, they've established themselves as businesses there. They have offices. They're receiving a lot of benefits from doing business there. And so, you're going to be subject to the regulation in that way. They will have to try to find ways to continue, if they want to continue to do business in China, which is increasingly more difficult. They will need to try to find ways to thread those needles to comply with their privacy laws, to comply with their AI laws and the like. And I think we'll continue to see a very delicate dance between large US tech companies and the government of the People's Republic of China. So those are some of the prohibited examples. What about things that are just high risk? So still permitted, but just more closely regulated. Of the type you would probably expect. I mean, things that are AI in systems or products that could cause harm to life and limb. Those are generally considered high risk. Critical infrastructure, sensitive areas like education and employment, where there's just a very strong history of, civil rights and equal opportunity and suspicion of how people are evaluated, public services, law enforcement, justice, democracy, immigration, and border control. So what they did is, again, instead of just saying, we don't like AI, and if your AI is above this certain particular threshold or spec, you're going to be automatically considered high risk. They took a different approach and they looked at the use cases. Now, if you were paying attention to the timeline earlier, you can see they started this law in 2021. They're just finishing it now. So in the middle of this process, what did they get? They got ChatGPT, right? They got the explosion of LLMs. So they had to kind of find a way as they were working through this law of regulating those companies as well. But if you read a lot of the reporting around, you'll see that there was a lot of lobbying in the EU as well. And in the end, they took a fairly light approach to LLMs. Again, they didn't just say, you're an LLM, we don't like your technology, we're going to regulate you. They're continuing to look at the riskiness of the use cases. I'll try to wrap it up here in a minute just so we can get to more questions. What are some of the things you have to do if you're a high-risk AI act? You got to do a lot of documentation. You got to do a lot of assessment of your AI for safety and other things. You got to keep records. You have to register with the European authorities. There's about, 50 or 60 pages. The entire law is like 270 pages, but there's about 50 or 60 pages just about obligations for providers of AI, of high-risk AI. I think I'll close with this. This is an interesting provision. I think it's right now, I think it's the most interesting provision of the act. So the act starts out, and like a lot of laws, it says, what are we trying to do? It says the scope, it says the applicability of it, provides the definitions. It's kind of how you write any kind of law. But then right in like the fourth article, right at the beginning of it, and it applies to all AI systems, not just high-risk ones, but any AI system. They include this kind of weird provision, say AI literacy. And it says this. It says basically the providers, meaning the creators of AI systems and the deployers, that means the customers that buy them. So someone who creates these systems or a company that buys them and uses them and deploys them, you need to do your level best to ensure that the people who are using it have a AI literacy, which ends up being a defined term in the act as well. And so this is sort of this language at the beginning of the act that provides this kind of overarching idea that everyone needs to smarten up. Everyone needs to smarten up, whether you're providing the AI, whether you're just deploying it, and you need to be thinking about the stakeholders that are impacted on it as well. So, if you're a B2C business, you got to be thinking about the C, not just about the B. So I found that to be just an interesting way to start the act. So we just kind of scratched the surface on a lot of things. I didn't really talk about what Congress is up to. They are up to a lot. I don't know that they're going to get anything done this year in terms of AI, but there's a lot of bipartisan consensus there. I've talked to a few different regulators and executive agencies in DC. When you ask them about AI, they're concerned with most of the stuff that gets the biggest headlines, right? Deep fake porn, robocalls in elections, all the things that you're probably going to see, more written about between now and election day, that's where their mind's at. They're not trying to solve for kind of bigger, broader societal issues at this point. I think they'll get to that. But they might take the same approach as they did for privacy, which is sort of do nothing, wait for various states to figure it out. Once enough of the states kind of come up with a way of thinking about it, then pass a federal law and come up with a national standard. So it might be many years before we see, probably not 30, but it might be many years before we see like a thoroughgoing AI law in the United States that applies sort of across the board, similar to the way that the Europeans are doing it. And that's it. So that's kind of a high level summary. Let me take any questions that people have, and I hope that was helpful. Fire away.
Can you go to 2 slides back?
Yes.
To the specific, the very last phrase in here. Considering the persons or groups of persons on which the AI systems are to be used. Do you see, in this law, is there something that becomes a right to not exist? Because if they grab your facial recognition information because it was quote public domain, do you see them putting this in to be like, I can put in, you need to remove all my facial images?
Yeah, well, fortunately, that's a great question. Unfortunately, in Minnesota, although I think we're working on it, there are a lot of privacy laws that already grant people the right to request their data to be deleted. Now, the challenge is kind of like whack-a-mole, right? Like if someone scraped the internet for your facial recognition, you might be able to get company A to get rid of it, but there might be companies B through infinity that also have it. But there are kind of privacy laws that are emerging in other states. Eventually we'll have one in Minnesota as well, or we'll have a federal law where you'll be able to request deletion of those things. The right to be forgotten is what it's called under GDPR. So we'll see more of that. And then there are kind of more tech solutions in that space that are trying to solve the whack-a-mole problem. Sorry, back row.
Yeah, staying on this slide, when I read that, so I look at it going down the path of, you need to pass your CPA to do that. You need to pass the bar to be a lawyer. You need to pass Series 8963 to be a financial advisor. Is that where we're headed with this? With standard setting bodies and things like that being formed? Or?
Yeah, there's definitely a lot going on in that area. I was going to mention the National Institute of Standards and Technology, and I'm proud to be at Eightfold. We're a part of their AI consortium. There's a lot going on there in terms of standard setting. One of the things some companies are thinking about is basically having sort of a driver's license for their AI powered technology, where there's a training that people need to take that they complete and shows that they understand how it works. Both, if it's used in multiple ways, like in employment, there's a recruiter and there's a job candidate, making sure they both understand how the product is working. So I'm not sure exactly how this will play out. And this isn't something where I think anyone's ever going to level a huge fine about it. I think it's more kind of normative. There isn't I would be very surprised if a European regulator said, you have a non-high risk AI and you really haven't done this very well, and so we're going to come after you. I think it's really just a way of saying this is how to set the table for a lot of the other principles that come up later in the law. I'm going to work from the back to the front.
How do you think the AI landscape is going to be shaped by copyright law in the US? I'm thinking of seems like there's a new lawsuit every week filed by someone who, it's like you trained on our copyrighted material without permission or paying us, etc.
Sure. I can give you, my own personal thoughts on that. Obviously, copyright was something that we were thinking about, at Microsoft and at GitHub and with OpenAI. OpenAI had a paper that they published online a number of years ago where they provided comments to, I think it was the Copyright Office. And it said, you really need to focus more on the outputs. Don't focus so much on the inputs. Don't focus on how it was trained. Focus on the outputs, because there's already existing copyright law that will cover all that. And I don't necessarily disagree with that. I think that is right. Like, you have to look at what the model's doing, what it's spitting out. I think there's a lot of good arguments for the way it's being trained. Probably falls outside of copyright because it's like a transformative use. What I'll also say is, you know, when you're product counsel at a company, you're not always giving advice to say there's no risk, or here's how I make all the possible pain go away. What you're doing is you're saying, here's the risks, here's the things we should anticipate, so let's not get surprised. So I was not surprised, and others were not surprised that people filed a lawsuit against GitHub, for example, around GitHub Copilot. What I'll say in my personal opinion is I think open source developers are a less compelling plaintiff than actors, musicians, and artists, right? I think those groups have clear financial interests. They have lobbying firms. They have a lot of power. So I think the claims that they bring will be a lot more interesting than open source developers. And I think, again, my own personal opinion, I can shut up if you guys are bored about this, but I think my own personal opinion is, you know, if I said to you, go paint me a portrait of my dog in the style of Andy Warhol, right? You could go out and do that. You could study how to be an artist. You could study the style of Warhol. You could create art in that style, right? There's some sort of line there, but generally that's all right. You know, if you're Bob Dylan, most of his early albums were in the style of Woody Guthrie, right? Like he didn't really have his own style until a few albums in. But the challenge is when you can do that at scale, when you can do that in a matter of seconds, where you never need to learn how to paint and develop the style. You know, I think maybe 20 years from now, the Supreme Court gets around to saying, maybe earlier, says, we need something that protects that sort of in the style of. But right now, I wouldn't say that existing copyright law does that very well.
It's so curious, since you've been, sorry.
No, no. Go ahead.
When an AI is used to attack somebody, as in the Taylor Swift situation.
Yeah.
Who does she get to go after? Who does she need to go after? I mean, because it's.
The lawyer.
That would depend on, I mean, it depends on a lot of things, right? Like, you know, generally you sue anybody and everybody that you can. That's the strategy. So I think she's probably very well represented, and her lawyers are probably identifying every single law and every single person that can be sued in that regard. And I'm sure they will be active on Capitol Hill as needed to create laws that address those things. Maybe I just glanced at it, but there's some new law around Elvis and the right of publicity and kind of using a voice in an AI. Some of the first rights of publicity laws came from Tennessee, like of all states. They came out of California and Tennessee, right? California, obviously, huge entertainment, you know, the state of Maryland, all these other things, right? But Tennessee has a really cool, innovative, leading approach to rights of publicity because of the Elvis estate. So we might see similar things expanding the right of publicity.
So, I'm gonna run an enterprise architecture practice, I do wherever I go, and I hang my hat there, I try to hit some kind of standard, so I use that risk management, NIST risk management framework. Is that, I mean, do you have others that we should follow? Because there's always that, you know, the lawyers that I work with, there's always a little bit of gap.
Yep.
And how do I make sure these applications, these vendors, what we're producing is compliant? So I kind of leverage that a lot. Are there others I really need to be researching and integrating in my practice?
Well, the EUA Act will kind of de facto become the standard, but right now I would say the NIST risk management framework, the AI risk management framework is very solid. It's totally voluntary. Obviously, it's not like a law. It's just a standard that NIST puts out and says, this is sort of what we think is the right way to do it. That standard is being revised as part of that Biden executive order. One of the things in the order is it orders NIST to take a look at that again and see if it needs to be updated, which it probably will. So that'll be, you know, if you're working with a vendor or you're working with a consultant, and they're actually doing that and they can show you their risk assessment, and you ask them things like, hey, what's your responsible AI policy? And they don't just go to ChatGPT and quick write one. They actually have something they're doing to think about how they're guiding their company. Those are very good signs for the quality of the vendor that you're working with.
So I spent a lot of time looking at, it's a pretty intensive part of the products in my career. On the one hand, they required no US government regulatory compliance, data storage, disk drives, things like that, but had intensive customer expectations and scrutiny and oversight. The other solar products, you can't sell those unless you go through a specific process of certification and validation, so on and so forth. But in that case, customers almost completely depend on that and aren't particularly attentive the way they are in disk drive world. We hear a lot of the AI acolytes going around about this massive risk and threat, right, that we have out there, many of the popular people, yet we treat the product like it's the former, not the latter. What?
I don't know that there's a rational basis for some why products kind of get rolled out. I mean, I can't remember who the comedian was, but you know, the notion was like, you could never invent a gas stove right now. Like imagine there weren't gas stoves, and imagine tomorrow someone invents a gas stove. Like, oh, it's great, you know, it's gonna heat really evenly. All I need to do is pump into your house this incredibly explosive scentless gas, right? And don't worry about it, it's gonna be fine, right? Like we inherit some products because they existed before like the age of the administration regulations and the rest of it, right? The motor car, the gas appliance, the rest of it. You know, they probably just didn't act fast enough to regulate data storage or something
Let me
like
ask
that.
Orla, do you think this phenomenon will wake people up to recognize that the regulation side of this technology, especially as it's claimed to be, whether you believe that or not, so it has to be heard itself. If you actually believe in that, then that it needs extreme oversight. And so the contradiction is really, really.
Yeah, I'm gonna have a hard time predicting that any better than anyone else. What I would say is maybe the Europeans have moved a little too early. It might make more sense to let things play out. But a lot of the things in the executive order as well are about job displacement. There's just a lot of concern about it. I think some of it, like I said, is just knee-jerk human reactions to AI. They want to get out in front of it in terms of whether there's job displacement. Aside from like what I mentioned, people in Washington are talking about in terms of, you know, deep porn and the rest of it. What they're really interested in is this fair? Is this going to aggregate existing laws? And is it going to displace jobs? Like are our constituents going to be displaced with this technology? Because if you're a politician, you're probably going to want to regulate in that area sooner rather than later. So there's a lot of kind of fear and doubt about it, but I can't predict whether it's going to be as bad or as good as people say.
That's not a stalling card because it's.
European Union laws, if you have a website here, it's a forum, at what point would you get into that? I mean, do you need users that are over there?
Under GDPR, it's generally whether you're kind of offering your services in the EU. And again, this isn't legal advice. Like obviously get your own legal advice if you need it. But the GDPR is basically around whether you're targeting or offering your services there. Like if someone incidentally starts using your services in Europe, that probably wouldn't trigger it. I would think this law is probably going to be interpreted the same way. You know, if you're not intending for the outputs to be used in Europe, if you're not intending for them to impact a resident of the EU, then you're less likely to have the law apply. Most times, most companies know whether they're going to fall under the law or not, because it'll be pretty clear.
What you can say about the GPUs regulations, graphic processing units,
You mean as a,
data centers for training models, will be regulated?
there are certain provisions of the EU Act that are tied to flops, tied to other measures, parameters of the EU, of the AI models. To be quite honest, I'm a lot less familiar with that because I'm not really a technologist. I'm a lawyer. But there are certain provisions that are tied to the size of the particular model. Some of those are around the large LLMs, but I don't know.
That's like impossible to do. I mean, how are you gonna pitch the GPU and say that the GPU is not comply? You know, it's the use of it, right?
Yeah, some of those provisions they can update over time, right? So as technology changes, they could change it, but it's really more about things like not regulating it, but defining it. When we say, you know, if they use the defined term general purpose model, then the definition will say something about, well, we mean things of this size.
I haven't heard of that.
Tom, I want to say thank you for, first of all, for the great information here. Don't want to help settle the lunatic fringe out there. I actually ammunition to share with them a little bit, so make sure they, get calm, right? One question I have is that with AI, companies are going to, can they be proprietary with their own AI? And in other words, copyright their own AI, and then of course we have open source AI because obviously that company AI is important data for the company. You don't want to lose that intellectual knowledge, that copyright within their own products and their space to gain ahead of competition. I suspect that would be an easy yes.
Yeah, I'm not like a hard IP lawyer either. Like I don't do patents, but what I would say is, the IP rights around AI are going to continue to evolve. You might not have rights in the training set or the data set or even particular approaches that you use in developing your AI. You'll probably have more success at things like the UI of it, the experience of it. And some of the largest companies in the space, they're probably less concerned about nailing down their IP rights as just kind of winning the network effect game. Like why do most people use ChatGPT? Well, it was the first and it starts to snowball. Why do a lot of people use GitHub Copilot? Because of the first and it starts to snowball. But there are probably a variety of IP rights that could be nailed down in connection with some of these things.
So a lot of the impetus that drives many of the developers, right, and the leaders, right, in the space, were some of the great visionaries who wrote a lot of sci-fi, right, back 60, 70, 80 years ago. One of them laid down 3 laws of robotics that are really fundamental and invariant, and they would apply exactly in this case. If we assume that artificial intelligence is the same or equivalent, congruent with this, robotic concept that was developed there, what's wrong with starting there? What prevents us from doing that?
Basically, I mean, that nothing prevents it. Obviously, like we could start from any basis we would want to, but I would say most of the laws that we'll probably see in this area will be around those notes that were on that slide. So, human centricity would be an example of one of those things that comes out of those laws. I don't remember, but the third one is like, you don't disobey the first 2, right? Or whatever it is. But yeah, human centricity, kind of public benefit, do no harm. And then,
It seems that people don't want to commit.
Yeah, perhaps. I mean, I would say like the EU Act does it in a roundabout way, right? They think about, well, what if HAL doesn't open the pod bay doors, right? Well, then someone's going to die, right? Well, then we're going to Dave's going to die. So we'll put that in the high risk category, right? Because it's a part of an aircraft or it's part of a life safety system or something like that. So I think they are thinking about human control and human centricity, but they're just limiting it to things that might be like around life and limb. So
I think it's amazingly ironic that we have this current time where we're being reminded of Oppenheimer, right, and what he delivered, right, or what he led delivery of, and then what he took responsibility for that delivery. At the same time, we have people who are claiming to deliver a technology with equal or greater power, but they're not actually mirroring that fortitude.
Sure, I'll give you my Oppenheimer riff because I did read American Prometheus. I think the most interesting parallels are right at the end of World War II, where we have the bomb and the Russians don't. And there's a lot of thinking about maybe we should just share with the world how you make the bomb, and we should make sure no one else makes these things, right? We should have kind of universally shared knowledge, and we should have sort of universal control. Obviously, we didn't do that. What we did is we started building more bombs. We thought we were 20 years in front of the Russians. We were only 4 years, unfortunately. Then we kicked off an arms race. I'm not saying whether that's right or wrong, but what I'm saying is we're at this point right now where we have really large proprietary models. We have these open source models that are evolving, but I don't think we have any real kind of debate in society about whether, well, maybe companies shouldn't have these as proprietary models. Maybe they should be shared more broadly rather than kicking off an AI arms race with the Chinese, right? So I don't know, that's just my own political opinion, but yeah, the Oppenheimer book has a lot of interesting things to say.
I think there's more to the story about there was the greatest generation and there's this generation and there's character and there's
Yeah, when you live through a war where millions of people die and they have to take a side, you're probably gonna have better politicians come out of that than the current slate that we have.
This is such a fast moving field, and like you, I'm not a software engineer. Do you have any advice for just staying afloat and keeping up with the latest developments from a non-technical person's perspective?
One of the things I did at GitHub when I first got there, and I had no idea what a pull request was, I had no idea what any of this stuff was, is I just took a course on Python, like online, and I learned a little bit about how to program. I've forgotten pretty much all of it, but I learned that. I also learned enough that when I used GitHub Copilot, I saw that it could do my homework for me in a matter of seconds. So that kind of registered like, oh, like this is going to be helpful. So I would just suggest kind of taking a class or two. I wish I had a bit more time. Like there's a lot of online courses and, you know, prompt engineering and others that these large companies are offering, or a course in statistics, just to get a little bit more familiar with what your coworkers are talking about. I don't think, like, as lawyers, like our job isn't to have our Venn diagram cover theirs. It's to make sure we're still doing our swim lane, but knowing enough about what they're doing that we're at least conversant.
A lot of what you're saying has been focused on companies and developers and major. What about individuals who do not use the technology, use it, quote, illegally, whatever illegally means,
Sure.
to do the Taylor Swift thing or the, you know what I mean, where perhaps are covered by the city of Minneapolis trying to
Sure.
Arrest them or something.
Yeah, for the most part, these large acts they're aimed at large players in the space. They're out to protect the little person or the little guy, the same way consumer protection acts are. If you're doing things, you know, illegally or unethically with an LLM, you're probably likely to be violating their, you know, acceptable use policies. They have trust and safety teams that are tasked with kicking people off their platforms that are doing that.
So they put them in jail?
No, they probably don't, but I mean, they might refer you places. If Taylor Swift's attorneys call up and ask them for information on your account, they might provide it, I suppose. You know, again, like the second or third slide, there are already a lot of existing laws. So just because you're doing something with AI, if you're violating someone's rights of privacy or publicity, or you're misappropriating their likeness, there's all kinds of numbers of things that you could be brought to task for under existing laws. If you're, you know, some anonymous user somewhere and you have $100 in the bank, you're probably not at a lot of risk here. Maybe there's some criminal penalties. But for the most part, these laws are aimed at very large players in the space to make sure that they're acting in a way that protects the little person.
Good question.
Oh, so I was just, back when you were mentioning I think you mentioned reference the 3 laws of ethics from Asimov. And so even there, it's like, even in the books, unfortunately for this, why they don't work. And in real life, at least in my opinion, it's a good starting point, but it's very hard to define them or utilize them in the contextuality. And say with, as an example, self-driving cars, and there's like the issue of, say, trolley problem, or there's an old lady on the street and then you swerve to hit the other person. But then when you actually consider it, it's very rarely that's the issue. Like we are at the point where you can't reliably recognize a person that is more of it if it's dark, say. And so we are kind of trying to run before we can walk and trying to define the absolute good and absolute right, where we have absolute good and absolute bad, when we have no way of differentiating them necessarily.
I'm gonna just agree with that comment.
So I was part of an IEEE program for their Internet Technology and Policy Initiative back from 2016, 2018, and I was part of the analytical decision making team. We talked about that specific example in the context of making policy. Unfortunately, that group couldn't bridge the divide between the ethicists that were on it and the technology people. the story of the technology people were all just completely captivated and wrapped around the axle of the nuts and bolts of how stuff worked. And the ethics people just thought the technology people were completely nuts and not giving any time or attention to what was actually happening to other people. And that we never got a single paper done. I actually was able to publish a very small paper about the policy elements of this. You're right that there are some ambiguities in those rules, right, that hasn't well defined, but that's what we're supposed to go nail down. Right?
All right.
That's exactly what we're-
Last question before the bar, and then at the bar, if anyone tells me a lawyer joke, I'll tell you my engineer joke. Yeah, it's you.
University, we have a team of advisors who advise students to what class they should take so they graduate on time. We're developing a chatbot to help students make these decisions. There are some people that think we need a statement for this chatbot, that it's hallucinating or making mistakes. Other people don't think we do. I'm wondering what you think in terms of.
Yeah, I think there's probably more going around and disclaimers on chatbots than there was a year ago. Like if you just sign up for ChatGPT or Claude AI for the first time, you'll see some of the disclaimers that they provide. They're pretty lightweight. I think most students, especially younger students, understand that these things have limitations, but it doesn't hurt to let people know, especially that, you're interacting with a chatbot. And I think that's probably apparent, but
Person advisors don't need a statement that our attorneys aren't concerned about that.
isn't that funny?
Yeah, right, but the chatbot,
Yeah.
some people think we do.
My last stored rant is a lot of when it comes to like, okay, you need to do a risk assessment around this AI. It's like, why don't we do a risk assessment around us not using this AI? Why don't we do a risk assessment about what it looks like? Let's take the legal practice, right? Let's take a risk assessment. How is the legal practice doing right now? Right? Like as Jimmy Carter said about 50 years ago, Americans are over lawyered and underrepresented, right? Like we have the same problem now, if not worse. So when you look at these things like, oh goodness, there's going to be AI lawyers and they're going to commit malpractice. And yes, these are important risks, but you need to look at what you have right now. We're not working in a perfect state. Like, is this an improvement over it or not? Most laws you see don't, unfortunately, take that common sense approach. Thank you. See you at the bar.